So welcome everyone to our first EHCP webinar. First of all, I'll introduce myself. My name's Louise Gillard and I run the Parents Connect service for Scope. We are working today with Erwin Mitchell. We have Natasha, Rachel, James and Lily from Erwin Mitchell who are going to be hosting the event, and they are going to be giving you hopefully all the information that you need. Scope, as you may know, is a national disability charity, but I work for Family Services and we're here to help the whole family when it comes to disability or additional needs. And I particularly help parents get through this long journey that we're on. We've been working with Erwin Mitchell for a long time now. Erwin Mitchell provides us lots of resources. They give up their time very freely and willingly for Scope. And they very kindly offered to do this for us because we were just getting so many questions at Scope about EHCPs and how confusing this whole process is. We originally were going to do this face-to-face. We had a big event planned in March and then the country got locked down. So Erwin Mitchell have been working really hard with us to get this online. What this has also meant is that we can also do this nationally, whereas before our event was just in Leeds. So welcome to everybody who's joined us that's not actually accessed our service before. I know we have a lot of people who are familiar with what we do up in Leeds, but it's good to be able to help people across the country as well. This session is going to be very general information because each area does vary in the EHCP provision. Rachel, who is one of Erwin Mitchell's solicitors, is going to be going through what your rights are around EHCPs, the appeal process and annual reviews. And then we have James, who is going to talk a little bit about how this has changed recently and how that may look going forward now. Obviously, this information's still all coming to light, but James is going to try and help you get a slightly clearer picture. We do have a lot of questions being sent in already, and we've collated them, and I will be asking those at the end if they're not covered in the session. But myself and Lily from Erwin Mitchell are going to be on the chat, so if you do have any questions as we go along, please input them into the chat and we'll either answer you on there or we will try and answer them at the end. I think that's it from me, so I'm going to mute myself and I'm going to hand you over to Rachel from Erwin Mitchell, who is going to start the presentation.
Thank you, Louise. Welcome, everybody. My name is Rachel. I'm a solicitor within the Public Law and Human Rights Department, and I specialise in education law. As Louise said, I'm here to talk you through the EHCP process today, and my colleague will then talk to you about how that's impacted by the COVID-19 pandemic that we currently find ourselves in. So we're going to talk about the education, health and care plans first. So in terms of the definition of special educational needs and the provision, Section 20 of the Children and Families Act is where you'll find the definition of a learning difficulty. And basically that means that a child or young person has significantly greater difficulty in learning than the majority of their peers in their schools, in their mainstream schools, and that also includes mainstream nurseries. And that disability either prevents or hinders them from accessing the education facilities available to them. The definition for SEN provision falls within Section 21 of the Children and Families Act, and that essentially states that this is education or training provision which is different to or additional to that generally made for others of the same age in mainstream provision. So the EHC needs assessment process set out to be a fairly simple process, but sometimes it's not. So you as parents have the right to request an EHC needs assessment, and that's contained within Section 36(1) of the Children and Families Act. So if you're finding that your school is not supportive of them making an application, you can actually do this yourself. So anyone can bring your child or young person to the attention of the local authority if they think an assessment is necessary. This could be a GP, social worker, health worker, anybody that's involved with the child. The criteria for an assessment is set out within Section 36(8) of the Children and Families Act, and that states that the local authority must assess if the child or young person has special educational needs, and it may be necessary for SEN provision to be made in accordance with a plan. Now, this is a much lower threshold than it used to be when statements of special educational needs were implemented. And so, as I said, the threshold is a lot lower, and more applications are being accepted because of that reason. I would just like to say that if you have a disabled child but they don't have any special educational needs, then there is no duty upon local authorities to assess the child, unfortunately. During the assessment process, there must be consultation with the child's parent or the young person, depending upon their age. And following your application, the local authority must notify you within 6 weeks of whether or not an assessment is necessary. As part of that assessment, the local authority are duty-bound to obtain advice and information from the child, young person and their parents. They're duty-bound to obtain educational, medical, healthcare and social care information. From year 9 onwards, they are bound to obtain advice to assist with preparation for moving on to adulthood and independent living, so for when they're leaving mandatory school age. And any person that you or the young person seeks that the local authority requests advice from. So, for instance, if you have independent experts working with your child or young person and you feel that their input into the assessment process is necessary, and you ask the local authority to contact them and obtain that information, then they have to do so. So, EHC assessment request, the Special Educational Needs Code of Practice at paragraph 914, the question is, has relevant and purposeful action been taken in order for the local authority to determine a request for assessment? So, does the school or you have evidence of your child or young person's academic attainment? This could be developmental milestones in younger children, i.e. those who go to nursery or pre-nursery age, and their rate of progress. The nature and extent and the context of their SEN, so how that impacts upon them. What action has been taken by the school already to meet the child's SEN? And if any progress has been made, is that as a result of the intervention that's been put in over and above what the school would normally provide to the children within its care? Evidence of the child or young person's physical, emotional and social development and health needs. This is quite important. We're seeing a lot of children and young people these days whose learning difficulties involve this area. It's becoming quite an issue, and so we need to see if there is any evidence of that. And then if there are, if the person is over 18, so they're a young person, do they require additional time to complete their educational training in college or at a, I can't think of the word, when they're training for a job? So do they need additional time to do that over and above, say, the 2 years that a child of 18 without special educational needs would require? So once the local authority have decided to carry out an assessment, they then need to decide whether or not they're going to issue a plan. Section 37 of the Children and Families Act asks is it necessary for special educational provision to be made in accordance with the plan? And I suppose there are two sort of questions to be asked when dealing with this question. Firstly, without a plan, can the child's special educational needs be met through provision in the resources normally available to the schools? And secondly, will they actually be provided? And there are two cases there which you can read at your leisure, which essentially said that the provision didn't need to be made in accordance with an EHC plan. So those are the two questions that you need to be looking at, really. If the local authority decides to issue a plan following the assessment, they must confirm to parents within 16 weeks of the request the outcome of the assessment, whether or not it proposes to make a plan, the reasons for the decision, and if it proposes to make a plan, it must then send you a draft giving you 15 days to respond and also to make representations on the school you require for your child if you want them to move schools. The draft education healthcare plan will look like this. So it has sections... Sorry? An education health and care plan will have these sections A to K. In terms of education, the sections you want to be looking at are Section B, which identify the child's needs, Section F, which identifies the special educational provision required to meet the needs set out in Section B, and then I is the educational placement. A good EHC plan will be specified and quantified. So Section B should describe all of their educational needs. And the more detailed and well-informed this section is, the better the provision the child or young person will receive in Section F. Section F should set out all of the educational provision to meet the needs in Section B. And this should be specified in terms of hours, staff expertise, the type of staff member, training, monitoring, reviewing, and there's a case there which you can read at your leisure, LV Clark and Somerset, which sets out what that consists of. The child or young person then has a legal entitlement to that provision set out in Section F, which is really important, because if that provision is then not provided, you have a legal remedy for forcing the local authority to ensure that it is provided. A lot of the time when you get a draft EHC plan, you might find that things such as speech and language therapy, occupational therapy, physiotherapy are contained within the health section of the EHCP. Unfortunately, if they're in Section G, which is the health provision, it's going to be unlikely for you to be able to challenge that through the tribunal. It's widely known now that all of those therapies can and should be placed in Section F, educational provision, because they enable the child to be able to access their education. Section F can also list equipment if it is shown that it can be educational provision, and this can include such things as a wheelchair for a non-ambulatory child or young person, for instance. And a well-drafted and detailed EHC plan can justify, where necessary, an independent specialist school if that is the school that you think is the only school that is suitable to meet your child's needs. So it's always important that if you're seeking the independent expert report to assist you with trying to get a plan, that you ensure that your experts are specifying and quantifying the provision and the needs as much as they can. So an example of provision would be, as we set out here, so for instance, little Johnny needs, say, 30 minutes of speech and language therapy provision delivered in a peer group of D characteristics of no more than E by someone with F qualification, so a qualified speech and language therapist. In an expert report, they should say why they consider this to be necessary and the reasons, what will happen to the child or young person if they don't then get that provision. So request for a particular school. When the draft plan is issued, you'll notice that section I is blank, and that's because the local authority is not duty bound to provide a school in section I when a draft plan is issued. So when you get your 15 days to respond and make comments on the draft plan, it's at this point that you can go back to the local authority and say, this is the school I want you to consult with that school. And if the school happens to be out of your local authority borough, and it can be, don't be fooled into thinking that you can't apply out of area, then the local authority also needs to consult with that relevant local authority. Now, the local authority must name the schools in the EHC plan that you choose unless one of these exceptions apply. The first is that the school you have chosen is unsuitable for the age, ability, aptitude or SEN of your child, or that the attendance of the child or young person would be incompatible with the provision of efficient education for others or the efficient use of resources. You'll normally find that the efficient use of resources is the exception that the local authorities will try to rely on in any request for a school which is an independent special school. The local authority must then name the type of school or the school that you have chosen which thinks would be appropriate. And there is a duty on schools and other institutions to admit the child or young person named in the plan. Of course, this is a little bit different with what's happening at the moment, but my colleague will go on to discuss that in a while. So the final plan, this should be issued to you within a maximum of 20 weeks from the date of the request. A copy of the final plan should be sent to yourselves and to the school named in the plan. And where the plan, where the local authority maintains the plan, it should ensure that the special educational provision is provided, so that's section F. And then the responsible CCG must arrange for any specified healthcare provision, which is set out in section G. And here we have a quick flow chart which just puts into summary what I've just gone through. You notice on the right-hand side that throughout this request for an assessment process, you'll see there are various rights of appeal. So if the local authority refuses to assess, you have a right to appeal. If they refuse to issue a plan, you have a right to appeal. And if you're not happy with the contents of the final plan, you also have a right to appeal. The annual review meeting. So once the EHCP has been issued, the local authority must review it at least annually. The following people on that slide must be invited to the meeting. That doesn't mean that they will attend, and more often than not, a lot of them don't attend, but they will put in reports which can be discussed between everybody. So don't be alarmed if a lot of people don't turn up to them. The local authority officer often doesn't turn up, but they do have to be invited. And I say that the annual review meeting is held at least annually. If you consider partway through your year that the EHCP isn't working or the placement isn't working, you can request an interim annual review. You don't have to wait the full 12 months. So following the annual review meeting, within 2 weeks, the schools must prepare a written report with the recommendations as to whether or not to maintain the plan as it is, make some amendments, or cease to maintain. They will then send that to you and to the local authority. The local authority, within 4 weeks of the meeting, must then decide if it's going to amend, cease to maintain, or continue the plan and let you know. If it decides to amend it, then it will give you 15 days to make representations, as you would have been given during the EHC needs assessment process. And if the plan is going to be amended following your representations, the local authority must issue you with with a draft within 8 weeks. So those are the timescales that local authorities are to be held to in relation to annual reviews. Decision making for young people. For those young people who turn 16 in by the last Friday in June of their academic year, the right to make an assessment request or make any representations about the content of their appeal, their school, personal budget, appeals, that all transfers from the parent to the young person. You can, of course, continue to support that young person, and in all the cases that I have come across, it's the parents who are making contact with us and asking us to help them with this. It's obviously their child or young person has difficulties, which sort of makes it difficult for them to give us that information. So you are able to still make those applications on their behalf. However, the final decision does rest with the young person. And so if perhaps you wanted them to go to one school and they wanted them to go to another, that would have to be looked into. The right of young people to make a decision is subject to their capacity to do so, as set out in the Mental Capacity Act. So in cases where a person lacks mental capacity to make a particular decision, that will be taken by a representative on their behalf, who will either be a deputy appointed by the Court of Protection or somebody who has a lasting or enduring power of attorney. Alternatively, if they don't have those, and in most of our cases they don't, then the decision will be taken by yourselves as the young person's parent. And this is likely to be the case in the majority of the cases we get. So the use of mediation, prior to the Children and Families Act coming into force, this wasn't really an option, but the Children and Families Act brought into use mediation as an option to appealing to the tribunal. So if you do intend to appeal or mediate, you do need to contact the mediation advisor, and that information will be contained in the letter that you get enclosing your final amended plan. If you decide to go ahead with mediation, the local authority has to attend. They can't opt out. But even partway through the mediation, you can decide not to go through with everything. You can have attendance of representatives at the mediation, and you can also have involvement of health if that is a particular issue that you wanted to be included in your plan. You can recover expenses for the use of mediation, and it's potentially your only opportunity to consider needs holistically during the whole process. But of course, you can consider an appeal to the tribunal under the national trial. And you also retain your right of appeal to the tribunal. Excuse me. So you can make appeals to the tribunal against the special educational needs element of the plan, and that section is the SNI. The local authority, as I said, must send out the information on appeal rights with the decision notice. You have to make your appeal within 2 months or within 1 month of the date of the mediation certificate. And the national trial, which covers health and social care recommendations, is currently in force until the 31st of August 2020. We're not sure yet whether or not that will be extended, but at the moment the deadline is just 3 months away. These are the appeals which can be made to the tribunal. I've discussed before. The national trial enables you to make an appeal in respect of health and social care, but you do have to have an educational element to your appeal as well. You can't just make an appeal in relation to the health and social care issues. You do have to have an educational element. Failure to follow any recommendations made by the tribunal, which are non-binding on them incidentally, could potentially be subject to a judicial review claim to try and get that provision in place for your child or young person. Judicial review is a remedy of last resort, and it's where the High Court reviews the lawfulness of decisions made by the local authority. You only have a strict 3-month time limit to make an application for judicial review, but the idea is that you make your application sooner rather than later. A lot of cases can be jeopardised by applying right at the 3-month deadline. So if you do have any of the issues listed below on the types of decisions that can be challenged, you need to be coming to solicitors or charities who may be able to advise as soon as possible, rather than trying, day on day, week on week, to get things resolved with your local authority. Funding. So private funding is available for all education matters. Public funding is available from the legal aid agency, but it is subject to income and capital threshold. So legal aid is available for judicial review, and the eligibility is based on the means of the person to whom the remedies would be sought, i.e. the person bringing the challenge, the young person or the child. Legal help for special needs matters, including appeals and disability discrimination claims, is available, but it doesn't include representation at the hearing, and that is something that you would need to fund on a private basis. Eligibility is based on the financial means of the person with the appeal right. So in terms of children under 16, the appeal right is with the parent, and those over 16, the appeal right is with the young person. So that's how the funding eligibility falls. If you find yourself in one of these situations and you require public funding, the number there is for you to call to go through to the gateway. They will take you through a means assessment, and they will then put you through to one of their panel solicitors for legal help. There's also a legal aid calculator link there on the slide, which you can click on. Take maybe 5-10 minutes to fill in your details, and it will let you know whether or not you're entitled to public funding for certain issues. And then there are just some questions which came through prior to the webinar. Thank you very much for those. And we've just sort of grouped them together rather than dealing with individual questions, and just put a slide there with some questions and answers. So I hope that's been helpful. I'm now going to pass over to my colleague, James Beck, who's going to talk about the impact of COVID on SEN provision as it stands. Thanks very much.
Thanks, Rachel. So I'm James. I'm a solicitor in the public law department as well, specialising in education law. So what I'm going to look at is what impact the coronavirus has had on special educational needs law and how that's delivered in practice. It's going to be a bit of a whistle-stop kind of guide through it. We did do a similar webinar a few weeks ago, and we had an hour for this topic. Obviously now I've got a lot less than that, and there's also been some further changes since then that we need to look at as well that have been brought in. So apologies if I'm rushing through. It's just to try and kind of give you all of the key points. And I think the slides and the recording will be circulated after this. So if there's anything that you need to go back to, then the detail will be in the slides, and there's links to the relevant guidances and things like that. So, sorry, I'm going the wrong way here. So, you may have been aware that the government brought in the Coronavirus Act a month or so ago, and there's different pieces of guidance that have come off that as well. So I've listed the key pieces of guidance in relation to kind of children with special educational needs and education issues below. So those are the key ones really, and we'll look at those in more detail as we go through. So the Coronavirus Act, what it does is it basically sets out a number of things in terms of education law that can be changed. And up until the end of April, there hadn't actually been any changes made. So it was all just about things that might happen. At the end of April, the government did bring in some changes, and we'll go on to look at those. So there's new regulations now that amend the existing SEN regulations. And basically what they do is provide the local authorities with a bit of flexibility in relation to the timescales for EHCP plans and assessments. So those timescales that Rachel kind of took you through, there have been some changes to those. So we'll look at that. The duty to deliver the provision in the plan has also been watered down to one of reasonable endeavours. So previously there was an absolute duty to deliver any provision in the plan. Now local authorities have to exercise reasonable endeavours. So we'll look at that in a bit more detail. As things stand, everything else that Rachel's gone through remains the same at the moment, but there is scope for further changes, so we'll look at that as well. So basically, the changes have been made and the changes that can be made are all dependent upon the Secretary of State issuing a notice. So that's what the Coronavirus Act says. And what that notice should say is what duties are being changed and why the Secretary of State considers that's appropriate. And that notice can only run for a period of 1 month at a time. And at the end of that, Secretary of State has to look at it again. But in theory, they could then issue another notice extending it. So that's what's happened in relation to this change in the duty to deliver the provision in the plan. The Secretary of State issued a notice at the end of April saying that that was going to be changed to one of reasonable endeavours, which is what we'll look at. So previously, in April, there was still an absolute duty to deliver anything in the plan. So if, for example, you had an EHC plan that said your child is entitled to an hour of speech and language therapy a week or full-time one-to-one support, that just had to be provided. There was an absolute duty on the local authority to provide it. Now, that's been changed to basically say that local authorities have to use their reasonable endeavours to do that. And the reason the Secretary of State issued that, what they said is that that might not be possible because, for example, a child or young person might not be attending a placement anymore. So, for example, if an EHC plan references a class size, a child being educated in a class with similar peers, children that have similar needs, that might not be possible anymore if they're being educated at home. Also, social distancing guidelines may prevent what education settings can do, and there might be difficulties in terms of resources and services. So that's kind of basically the Secretary of State is saying that it might be that staff, for example, aren't able to work or due to illness or self-isolation or staff being directed somewhere else because of responding to other pressures generated by the coronavirus. So that's why the Secretary of State issued the notice. So really important thing there is, I guess, there's nothing there about money, about it being a financial thing. It's more about if it's not practically possible or there's no one there to deliver it. So what the local authority or the health body, because this change also relates to any health provision specified in the plan as well, should consider is things like this, the local circumstances. So what is the workforce capacity? Have the schools been closed? What are the social distancing measures that people are having to comply with? what are the needs of the child, what are the views of the child and their parents about what provision might be appropriate. So all of this should be considered in order to work out whether or not we're going to be able to deliver the provision in the plan as a local authority, and if not, why not? And what there's guidance there, which I referred to previously. It's guidance on EHC plans. You can read it, it's on the website. That says that if local authorities decide that there is going to be a change to the provision in the plan, it should confirm that to the parents or the young person if they're over 16, explain what it's decided to do and why, and then keep the matter under review. So the key thing there is there should be an assessment, and reasons should be given by the local authority if they are going to change it. So if, for example, they're saying we can't deliver what's in the plan, they should explain why and what they're going to do instead. And the guidance from the government reiterates that what this doesn't mean is that local authorities don't have any responsibility anymore. They must still consider what they can reasonably provide in the circumstances during the notice period. And also, key thing is the notice is only for a month, so this is just during May at the moment. So for some individuals, that might mean that the plan can continue to be delivered. So, for example, if they're still attending school and they can still deliver everything, then that's fine. But for others, there might need to be temporary changes. And again, the guidance emphasises that once the notice ends, local authorities and health bodies must then look at securing all of the full range of provision again. So it's a temporary thing, okay? So what might this mean in practice? So, for example, I've got a client at the moment that's receiving online tutoring from a tutor each week. It might mean a temporary placement in a different school, but that should only be, that would be dependent upon you as a parent agreeing. It might mean direct education in the house, but that would need to be subject to a risk assessment because obviously there are risks with the virus spreading. For example, for a child with a visual impairment, it might mean enlarged materials being provided in the home by the school. If a child requires therapy provision, it may mean that those sessions are delivered by video, or maybe the therapist models exercises for parents to then do with the child at home. If a child is in receipt of a personal budget and direct payment, it could include maybe widening that use to enable you to purchase equipment to use at home to support home learning. And also the guidance mentions that, for example, it might mean thinking about whether or not equipment can be loaned for you to use at the home. So maybe can the school lend you any specialist seating equipment or IT that may be that might be useful. So that's the key change really to that duty to deliver the provision in the plan. So it's not a get out of jail free card. They still have to be doing something, and they need to be explaining why if they can't deliver everything in the plan. The other key change was made by the amendment regulations that were brought in. These were brought in and applied from the 1st of May and are in force at the moment until the 25th of September. And essentially what these regulations do is that they basically say all of the timescales relating to EHCPs. So I've listed all of the examples there. So these are the timescales Rachel talked about in relation to how quickly local authorities must consider needs assessment requests, how quickly they should issue plans, timescales for doing annual reviews, arranging mediations if parents are looking at appealing, for reviewing direct payments. All of these types of decisions now, those timescales aren't an absolute timescale anymore. What this regulation does is basically says that if, because of a reason related to the coronavirus, it's not possible to comply with the normal time limit, they must instead be completed as soon as practicable, or in some cases, as soon as reasonably practicable. And there's some guidance that I've linked to on the slide that sets out all of the specific changes. Okay, so there isn't an absolute timescale anymore. Again, the purpose of this is to give local authorities greater flexibility if they're under just extreme pressure because of the coronavirus. Key point is local authorities must still consider requests for EHC need assessments. So you can still make those requests and local authorities should still consider them. If your local authority has any blanket policies during this period, so say, for example, they just say, we're not going to consider any requests, or we're going to take 30 weeks to issue a plan instead of 20 weeks. Anything like that, which is just kind of a blanket policy, will probably be unlawful. Okay, and if you're kind of being prejudiced because of that, then by all means seek legal advice, because that will probably be unlawful. Another key important point is that any deadlines that fell before the 1st of May are still, the amendments, the regulations don't apply, so you can still take action. So if, for example, you were due a decision as to whether or not the local authority were going to carry out an EHC assessment, and that was due in April, this doesn't help the local authority. They should still have issued that decision by now, and you would be able to, for example, commence judicial review proceedings if you had concerns about that. And most judicial reviews are resolved through correspondence. You don't actually end up having to issue proceedings in court. So there are still things that you can do. Other potential changes. So the Coronavirus Act says that at the moment, if a school's named in a plan, there's an absolute duty that school has to admit the child. The coronavirus could change that to mean that schools don't have to do that. Again, to be honest, I envision, even if that happened, I don't think that would make much difference in practice. Schools will generally want the children to be able to attend because obviously they get funding through that. I think it's more just in case, probably to give some flexibility if, for example, the school just isn't able to open, or kind of situations like that. So I don't imagine that having any major impact, but yeah, it's a change that could be made. At the moment, there's a duty to carry out an annual review every 12 months. That again could be disapplied. And also at the moment, there's a duty to provide suitable education for children that are out of school for whatever reason. So this applies to children irrespective of whether or not they have an education and healthcare plan. At the moment, that hasn't been changed, but again, the scope for the Secretary of State to issue a notice about that. So those are the potential changes. So what should local authorities still be doing? So important things to note are they should still be assessing children that might need an EHC plan and doing EHC assessments, albeit that the timescales for those, they now have a bit of greater flexibility. And the criteria for deciding whether or not to issue an education and healthcare plan or carry out an EHC assessment hasn't changed either. So local authorities shouldn't be kind of refusing to do assessments because of this. The law is the same. They should still be applying that test that Rachel talked about. Local authorities should still be using reasonable endeavours to ensure a child receives the provision in the plan. If, for example, they're doing an assessment, then local authorities should still be taking steps to make sure that evidence is collected during that assessment. So it wouldn't be good enough to just say we're going to place this assessment on hold because the educational psychologist can't do anything. They need to consider, for example, doing that assessment by kind of Skype or other remote means. Local authorities should still be consulting with schools if, for example, they're issuing a plan to decide what school to name in the plan. Again, they need to think creatively about this. Annual reviews should still be happening where possible, for example, by video call or even on the papers. And the guidance about the EHC plans that I referred to kind of contains a lot more information about that. And you can still appeal to the tribunal if you disagree with a decision. So moving on. So I've just mentioned tribunal appeals. So tribunal is still operating as normal. They're actually doing all hearings now, mainly by video. That seems to be working well. To be honest, that has been worked so well that the tribunal are being able to get through more hearings than they have been doing before. Because judges aren't having to travel around all over the country, so they can fit more hearings in each week, and they don't have the problem they used to have in terms of finding venues. So that's actually been useful, I would say. They are a bit busier though, so it's harder to get through to them on the phone, and there are practical issues about kind of how do local authorities prepare bundles, where possible, they should still be sending paper copies to parents. But the key thing there, I guess, is, yeah, the tribunal is still operating. The time limits for registering an appeal that Rachel talked about still stand. So that 2-month time limit is still there, and you need to comply with that. So obviously schools are closed at the moment, so I'm just going to have a look at that. So the government have said obviously that they hope most children can stay at home if safe to do so. There are 2 exceptions to that, which are children of key workers, they can attend, and also vulnerable children and young people. And anybody with an EHC plan is classed as a vulnerable child, and so they can attend school if that's appropriate. Now, obviously, for some children with an EHC plan, that might not be appropriate. And what local authorities should be doing there, in conjunction with the school and in consultation with you as a parent, they should be doing a risk assessment to decide whether or not it's better and safer for that child to be attending school or not. And if, for example, they're not going to be attending school, that risk assessment should inform what provision is going to be delivered at home. So if, for example, your child's at home at the moment and not attending school, and you've got some concerns about kind of what's happening and maybe the level of education that's being provided, one question I would have is, has that risk assessment been carried out? And if not, I would suggest that you ask for that. So, yeah, we've mentioned, I guess we've mentioned this already. Basically, in terms of a child with an EHC plan, there'll be 2 categories really. There'll be children that maybe it's going to be safer for them to attend school, maybe because their needs can't be met at home and they need that level of specialist care that can be provided at school. Local authorities should support that. That might need to involve deploying staff from elsewhere to enable them to safely attend school. On the other hand, you'll get maybe some children whose needs can be met at home, and that risk assessment should be informing what extra support is needed there. So, big news, I guess, over the last week or so is that the government have said that schools are going to be reopening from the 1st of June. That's going to be done on a phased basis. There's new guidance that has been issued alongside that, so I've listed the name of it there, called Opening Schools and Education Settings for More Pupils. So do have a look at that. The first phase will relate to children in nursery, reception, year 1 and year 6. In primary schools and secondary schools and colleges, what it says is that there'll be some face-to-face support to supplement the remote education of year 10 and year 12 students who are due to take exams next year. We don't know yet what other further year groups will be asked to attend and what the next phase will be. Again, one question that we've been asked is, can the local authority make my child go back to school if they have an EHCP? And again, it's similar really to what we were talking about already. What the guidance says is that that decision should be informed by a risk assessment. So a local authority, again, should be making sure that a risk assessment takes place to decide whether your child's needs can be met safely in school, or would it be better for them to remain at home? So that's how that should be dealt with. Sorry that I'm flying through things. I just want to make sure that we've got time for questions. So in terms of GCSEs and A-levels, they've obviously been cancelled this year. Grades are to be awarded by teachers. Ofqual have issued guidance to teachers about how to award these grades. And there's going to be some level of attempts to ensure some consistency between different schools and settings. They've also recently consulted on how grades will be given and what an appeals procedure might look like. So we're still awaiting the results of that consultation. It has closed now. I imagine that will be published relatively soon, given the urgency. Ofqual have already confirmed a couple of things, though, following that consultation, and those are listed there. So students entered for exams in year 10 and below will be eligible to receive calculated grades this summer. For private candidates, so that means children that aren't attending a school, maybe being home educated, they will only be able to receive a mark through centres. So I guess in terms of anything else, we just need to await to see what the decision is following the consultation that's been carried out. So some questions that we've been asked. So I just thought we'd quickly breeze through these. So families that have had a draft and then final copies of a plan but have been self-isolating and so haven't been able to deal with it, will they get a reprieve in timescales to go to tribunal? Key point there is the timescales are still the same. So the 2 months to register an appeal from the date of the decision. So they've not been changed by the Coronavirus Act. So if you are outside of that 2 months because of the coronavirus situation, you'll need to explain to the tribunal why you're registering it late and flag that up. They might still be able to register it, but yeah, generally you want to be getting them in within the 2 months if you can. Another one, someone asked, my annual review was sent in some months before lockdown. In that report, I'd requested for my son to be moved to a different school. Nothing's happened since. So this is a type of issue that should be unaffected by the Coronavirus Act, because it sounds like if that annual review was some months ago, the deadline for making a decision probably fell before the 1st of May. So that timescale would still apply and wouldn't be affected by the regulations. So do seek legal advice if you're concerned about that delay. How will annual reviews take place for those that have been at home and so haven't had professional involvement? So in that situation, it might be more appropriate to use a simpler format, maybe gather information electronically, hold the annual review meeting by phone. Professionals are going to have to make do with the information that they've got and maybe trying to get more information remotely through telephone calls, things like that. How are timelines and assessments going to be affected by last week's announcement and phased school returns? So, yeah, a key point there is timescales have changed now due to the regulations to give local authorities more flexibility, but that doesn't mean they get a get out of jail free card. They still need to be looking at progressing assessments, doing things remotely. So hopefully that answers that question. Can they make us send children into school who have an EHCP? Again, I think I touched upon this. The guidance says a risk assessment should be undertaken to determine if appropriate. So if your school or local authority is saying your child has to attend and has to go back to school, I think you'd be entitled to say, well, has there been a risk assessment? And then that needs to happen first, really, to inform that decision. Can we still apply for education and healthcare plan needs assessments? Yes, the answer is yes. If a child isn't attending, what expectations are there about support at home? So again, in relation to that, local authorities should still be using their reasonable endeavours to deliver as much as the plan as possible. And if a child has complex needs, then they should still be able to attend school if that's appropriate. Someone else raised concern, how will schools support individuals most at risk of COVID when returning, bearing in mind that vulnerable children might not understand social distancing? So again, that's the type of thing that should be taken into account as part of the risk assessment when working out whether or not whether it's safe for a child to attend school or not. And if they are going to go back, then that risk assessment should think about what can be done to kind of promote safe social distancing. So that risk assessment's key, really. Another question, our usual speech therapist has been furloughed. We found somebody else who can do it. Can the local authority fund that in the meantime? If they say no, can we do anything? So yeah, that's the exact type of situation where local authorities need to be thinking flexibly. And if you've got an alternative and you can say, look, I want this I found this person, then local authorities would have to have a good reason why if they weren't going to agree to that, if that was something in a plan. How do you challenge it if the local authorities say no? That's where judicial review comes in, and obviously what Rachel talked about there. And like I said, bear in mind, most judicial reviews are sorted by a quick letter to the local authority to say, look, you should be doing this. Please can you do it? Otherwise, we're going to take court action. And most of the time, that gets the result that you need. What about if children have been newly diagnosed and aren't on an EHCP yet? So again, children without EHCPs aren't classified as vulnerable under government guidance. They may still fall into that category, but schools are still under a duty for those children to make reasonable adjustments, take into account any disabilities that they may have. I think final question, 2 of our local schools are closed entirely. what are local authorities' obligations. So if your school is closed, again, local authorities should still be risk assessing to find ways of supporting them, maybe in a different school or safely at home. So I think that was the questions that we got in advance. We've got a few minutes if any further questions came in.
Yeah, so thanks, James. I've been collating the questions. Lily and I have answered a couple, but I've tried to generalise some of these that we have got. We're getting quite a few questions about what evidence parents should be collecting to go to appeals. So what would we recommend they collect themselves?
I guess firstly, it depends on what's an issue. So what are parents appealing and why have the local authority said no? I guess a lot of the time, a lot of appeals will relate to local authorities refusing to do an education and healthcare plan assessment. In that case, in an ideal world, if it's possible, then things like independent educational psychology reports can be really useful, because the problem that often parents face is that the local authority reports that they obtain during the assessment often aren't very specific in terms of what's needed. And so sometimes parents can be in a difficult position because they've not got kind of evidence that goes into maybe the level of detail that's needed. So certainly independent reports. The tribunal will be interested in your views, so you can set those out in as much detail as possible. If there's any other professionals that work with the child, so maybe in clubs that they go to outside of school, then that might be useful. But again, independent reports from an educational psychologist, potentially a therapist as well, might be useful, but it completely depends on, what's at issue, I would say. Does that help?
Hopefully, yeah. I'm just reading them, so I'm just reading down what we've been sent in. So, hopefully, if anyone feels like the question hasn't been answered, please email us again and we'll try and give you a more detailed answer. But we have received a lot of questions, so we're just trying to cover as much as possible. I've got a question about the type of provision. I have a parent where they have, the authority have said the child must be homeschooled, and they would like their child to actually go into an education provision, into a school. Can that be appealed? Whose decision is it, the type of provision that the child goes to?
During the coronavirus, is that?
No, just in general. So this might be more one for Rachel.
Yes, that decision can be appealed with the tribunal. It's very similar to if the local authority doesn't have a school that they consider the child should go to, they will normally put a type of setting rather than name a setting. So if the local authority want your child to be homeschooled and you want them to go to a setting, then the remedy for that would be to go to an appeal, but obviously you have to have an appeal right in relation to having a decision relating to the final plan.
Yeah. What I'd say there as well is generally children should only be educated at home. If we forget about the coronavirus, generally speaking, children should only be educated at home if school-based provision is deemed to be inappropriate, which is quite a high threshold. Mm-hmm. So I would say it's generally quite unusual that a local authority would take that position. And I think if you did appeal it, it'd be quite hard for and you had a particular school in mind, it'd be quite hard for the local authority to argue against that, because they'd have to show that just it's completely inappropriate for your child to attend school-based provision. If anything, we normally find the opposite, where we're instructed by parents where they want a home education programme and local authorities are refusing to do that.
Yeah, I must admit, I would have thought it would be the other way around. So when really the parent needs the reasons as to why they're insisting on homeschooling, and they need to be good ones, don't they? And just on the subject of homeschooling, can you apply for an EHCP if your child is homeschooled? And how do you do that? I presume you just do it as a parent?
So the fact that your child's homeschooled makes no difference. You can still make that request for an assessment. It must still be treated in the same way. I think we also had a question about, can I request an assessment if my child attends an independent school? And again, it's still the same.
Thank you. Oh, sorry, I'm just reading through these. If a child has been refused a school place and the parents haven't been given a reason why and no consultation, is that grounds for an appeal? I'm not quite sure what they mean by school place, whether it's a specific school they want.
Do you mean in relation to a child with no SEN, in other words, a general school admissions or...
Right, he has an EHCP, but they were refused a place at school.
So the local authority have refused to name that school?
Maybe, yeah. Yeah, sorry, it's maybe that's one we need to follow up a bit later.
No,
sorry.
That's definitely one of the ones where parents would be able to appeal. Whenever a plan is issued, you get a right of appeal. Once it's finalised, you get a right of appeal. You have 2 months. So if you disagree with anything in the plan, so including the school named, then you can appeal to the tribunal, and that's what you'd need to do if you disagreed with the local authority's school decision.
Yeah. Sorry, I'm just reading through. And the evidence, so we've covered evidence. Someone's asking about, do they need to go into detail with the evidence and the application? And I'm a parent myself who's applied for an EHCP, then yes, I would think as much evidence as you can give the authority and as many examples as you can give. Don't generalise, because they need to know that child.
The more information you can give the local authority, who will then pass that on to a panel who may not have any idea about your child or the circumstances, the better. So the more detailed you can be in your application, the better chance you're going to have getting a positive result.
But I guess the other thing is that if maybe you've not got all of the information at the time that you register your appeal, don't worry too much, because what will happen, you'll register your appeal, a hearing date will be set, but you'll have up until about a month before to file any further evidence. So that gives you a bit more time to, for example, maybe get any extra reports that you might want to get and get any further evidence. So, yeah, don't worry if you've not got absolutely everything you need at the time you register the appeal.
I think that was a question about applying for the EHC needs assessment.
All right, sorry, my mistake.
No, fine.
And then just on appeals, if you've had to go to appeal for an assessment to take place, and then after the assessment takes place, the authority decide not to proceed with an EHCP, do you have to go through the whole tribunal process again, i.e. go through another 12 weeks timescale, or can it be sort of the original tribunal be reviewed? Is it a case of going through tribunal at every stage?
Yes. Well, you have two options. You have the option to mediate, or you have the option to appeal to the tribunal, but it would be a new tribunal appeal. It wouldn't go back to the original panel for them to consider that, because it's a different question.
Right. And if things are happening in the timeline, who's best to contact? I would have thought that's the local authority, maybe.
Yeah.
It depends.
Yeah.
Sorry, James. You carry on, James.
No, I just think, usually all of these duties are all by the local authority. So, yeah, all the timescales due to deliver the provision in the plan, ultimately it's all the local authority. So I'd suggest maybe your caseworker, your SEN caseworker in the first instance.
Yeah, and from experience that we've had with parents is once you get a caseworker, get their email and phone number, and when you call, ask for them personally, because if not, they're quite big departments for some of these children's services, and these messages do get lost. And make sure you've got a name and a contact, and don't be fobbed off. Just keep trying and trying. Yeah, yeah. Right, I know we... What's that, sorry, Rachel?
I was just going to say, if the local authority are not complying with the timescales for a significant period of time, and so you find yourself completely outside the 20-week timescale. There's, you know, only so much you can do to keep contacting them. In the end, you may want to consider contacting a firm of solicitors or a charity such as NAS or IPSI or SOS SEN, talk about potentially sending a letter before claims for breach of their duty to comply with timescales with the EHC needs assessment process. Don't let it go on for months and months.
Yeah, there are several people out there that can help. Like I say, IPSI are really good, and locally you may have organisations that will help through this. And like I say, solicitors, if you're wanting to take it further and go down the legal route as well, because it's not perfect. They have this duty, but things do sometimes get lost in translation, and, you know, sometimes it doesn't work out, so you can seek extra help. And I would thought as well, anyone that's talking about multi-agency meetings, again, go to your local authority and ask, because they may work differently in different areas. We're getting a lot of questions coming in over the chat, but I know we're over time. So what we'll do is, anyone that's not had a question asked, or if you feel like we've not gone into enough detail, it is hard because we are doing a very general presentation here. And like I say, it does vary area to area, but we will get in touch and try and answer your question the best we can. And let's say on the slides, a lot of the questions have been answered. So at the end of Rachel's presentation, there's several questions on those slides answered as well. But if we haven't, please get in touch with us. We've had a lot of people on this morning, a lot of questions, so we may have missed the odd one. So please get in touch and we'll do whatever we can.